1 CACV 19-753 Mago versus Arizona Escrow. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the bottom of the screen to help, but the time's pretty much on your own. We are recording the argument in audio and video, obviously. So when you begin your argument, please identify yourself and your client so we know who we're listening to when we review the recording. The argument will be up on YouTube in a few days. We've read the briefs and conference case, and we're familiar with the argument. So when you begin your argument, just start right out to tell us what you want us to know. Counsel, you may begin.
Thank you, Your Honor. This is Gordon Buehler for the appellants, Ruchira and Naresh Mago. And may it please the court, I am arguing for them today. I would like to begin by reserving 6 minutes of my time for rebuttal argument,
Sure.
just as a matter of housekeeping. And before I start, I would like to ask if everybody's hearing me clearly enough.
Yes.
Okay.
Yes.
Thank you. This is a new environment that we're in, and I'm cognizant of that, and want to be able to communicate, even though it's a different circumstance we find ourselves. The case is about the responsibility for the loss of $79,000 in escrow funds. That's what the case is about. I don't think anybody would question that. Our clients the Magos entered into an agreement to purchase a Subway sandwich shop location from Don and Judy Fulgham. As part of that, the Magos deposited monies with Arizona Escrow. That was the company that was designated as the escrow agent in the parties' purchase agreement. In fact, I think Arizona Escrow was the escrow agent for the majority, if not all, of the escrows of the Subway franchise purchases at that time. As part of that transaction, there was an email exchange in which a fraudster entered an email string between Mr. Mago and Arizona Escrow, and he inserted fraudulent wiring instructions, a fraudulent wiring location, and Arizona Escrow wired the $79,000 in Mago's monies to the fraudster, and it was never recovered.
Can I ask a question? What was there an email that was sent first to Mr. Mago? The email that we have just shows the email from Mr. Mago that contains the incorrect email address for the Fulghams. Was there also an email that in the record that someone sent to Mr. Mago that he then forwarded, or was there some other means of inserting the wrong email address into his computer?
I'm not sure I'm following exactly the question. The fraudster inserted himself in the email string between Mr. Mago and Arizona Escrow. Actually, I think the fraudster, if I had to speculate, was the one who requested that the monies be sent. Our client was in India at the time, responded to that email, included.
But that's what I'm asking, is that email, was there an email that went to Mr. Mago from the fraudster?
We think that that's what happened, Your Honor. That's my best guess.
But that email is not in the record?
All the emails that we have are in the record. But again, how the fraudster inserted himself, look, I'm not 100% sure about how that happened. I do know that the claim has been made that Mr. Mago knew about this somehow. And again, as we cited in our reply brief, that's not true. Mr. Mago indicated that his AOL password had been dropped and that he had called AOL and they assured him that that was going to be rectified. Whether the fraudster was using the drop password as a way to hack the email or not, we don't know. But
well, it looks like I'm just looking at the exhibits with the emails, and it looks like on November 21st at 4:38 p.m., your client emailed the correct Fulgrim with a reply of thanks, and then less than 2 hours later, your client emailed the fake Fulgrim about having written to Helen to release the money. Please send her wiring instructions. So that's why we can't. Why did he have two different emails when within 90 minutes he's emailing one email to each of them?
I don't know that I have the answer to that question. There has not been an allegation that Mr. Mago, at least there hasn't been it hadn't been supported by any evidence, and it wasn't argued below that Mr. Mago intentionally did what he, waylaid his own funds. That hasn't been the accusation. The accusation has been, I think, from Arizona Escrow that Mr. Mago had reason to suspect that his emails had been tampered with because he testified that his password had been dropped by AOL sometime in September.
The allegation is that he's the one who introduced the incorrect email to the title company.
Well, I don't know. It depends on how you define introducing it. I mean, the altered email had to come from somewhere. It didn't come from our client. And there hasn't, at least if that's the allegation, there hasn't been any support for that claim. And that wasn't really litigated below in the trial court. In fact, there hasn't been any evidence presented to the trial court that Mr. Mago somehow provoked, or I don't know other word to use, somehow established the connection with a fraudster such that that he would use an incorrect email for the fraudster.
Well, the only email that we have that's got everybody's address on it is the email from November 22nd at 4:40 a.m. that's from the fake Fulgrim to both Mago and Arizona Escrow saying, here's the bank details for wiring. And then there's a response 4 minutes later from your client just to the escrow company saying, please release the $80,000 to the Fulgrims. But there was no email address on that. So your client wasn't saying at this email. He was just saying to the Fulgrims.
That is correct, Your Honor.
Okay.
Yes, this was part of the transaction. Obviously, they're involved in this transaction. There's a request by the Fulgrims, what our client thought was Fulgrims, for release of a partial payment. I will say that wasn't part of the escrow, wasn't part of the purchase agreement. The purchase agreement was also the escrow agreement. And so that wasn't part of that, the idea that there was going to be a wire. And I think that leads to what I think is the central issue. If one looks at Maxfield, if one looks at Burkons, if one looks at some of the other cases that we cited, Maxfield in particular, though, the standard of care requires an escrow company to ascertain the identity of the persons involved in an escrow transaction, and that includes the distribution of money out of that transaction, because if one reads Maxfield, that was what that dispute was about, the fact that the escrow company had given monies from the escrow to a party that they shouldn't have given the monies to. If that is the standard, then one has to think about what Arizona Escrow knew at the time of the transaction. In other words, what information did Arizona Escrow have that would allow them to say, hey, wait a minute, we have no reason to suspect something's going on here? Well, again, we knew that Arizona Escrow knew that the agreement provided for the disbursement of all monies at the close of escrow. The escrow officer, Helen Westbrook, testified in her deposition that an interim or partial payment was unusual. That was not their standard practice. If the duty of an escrow agent is to strictly follow the terms of the contract, that change should have been a warning to Arizona Escrow, and I think that is a warning that Arizona Escrow ignored. Arizona Escrow knew.
But
Yes.
did your client object to the partial payment? Oh, sorry, Judge Howe.
No, go ahead.
I'm sorry.
I viewed that as just, wasn't that like 79,000 out of 80, and that didn't seem to be a red flag for your.
No, it wasn't. Our client, our client was willing to pay the money. Our client was willing to satisfy whatever he thought the Fulghams were going to require. But my point is with regard to the escrow officer. The escrow officer having the contract in front of it, which is signed and in writing, those are the terms of the agreement, didn't provide for a partial payment. And that should have been some kind of a red flag with regard to the identification of the parties.
It seems to me that partial payment would be an issue only involving your client. Your client would be the one that would be providing the monies. Why would that call into question who's receiving the money as opposed to just whether your client's going to actually go through with it? I'm not following how that necessarily relates to the who the person who's going to receive the money would be.
I understand. Well, the reason that it's important is because it is a change in the terms of the written contract. That's the reason it should have raised a red flag. Here we have an account at J&G Art and Designs, that's the fraudster's account, that's nowhere identified in the written agreement, that arrives late, that is a change, again, testified by Ms. Westbrook as being an unusual situation. This change all should have led Arizona Escrow to do with the contact information that it collected, to do what it should have done, which was to pick up a telephone. It had collected both the cell phone numbers for for the Fulghams. It had the cell phone numbers for the Magos. It had correct email information. If it had started a new email chain, things might well have been different.
Could I ask you about the standard of care? You retained an expert apparently, but there's doesn't seem to be any report from the expert. Why have an expert, or why rely on an expert if there's no report filed in response to a motion for summary judgment?
Your Honor, that's a good question, but the reason for that is because the defendants, Arizona Escrow, stated succinctly and clearly from Mr. Caldwell's testimony what the standard of care required. And the testimony from Mr. Caldwell was direct by saying, look, the standard of care, given the information that that Arizona Escrow possessed, the standard of care required Arizona Escrow to use the contact information it had collected and to independently verify the wiring instructions because of obviously the things that had been happening in the industry. And so with the testimony of the unequivocal testimony, and there isn't other testimony that challenges that, we believe that was sufficient for the judge to determine the testimony and the position of Mr. Caldwell, who is the expert. In fairness, though, I mean, the principal argument, the first argument, I should say, not the final argument, but the primary argument is that with the facts understood in this case, really an expert was not needed. One could say that an expert would be icing on the cake, but really, when one looks at Maxfield and Burcon's and other cases that were decided without expert testimony, in fact, I couldn't find a case involving a title agency or an escrow company in Arizona that required expert testimony. With that understanding, the case presented facts that should have been presented to a jury, and they should have made that determination in this case.
Can I ask you about your contract claim? Sorry, Judge, how do you have a question? Go ahead.
No. My only question was, given the status that we're in, these arguments, these are issues for the jury. They're not legal they're not legal issues for us to determine.
Well, you're right. I do think the facts presented, well, I think it's a combination of facts and law. I think the facts presented legal issues and factual issues that need to be determined by a jury. And that's all we've asked. What we've asked for in this case is the opportunity to present our side of the case to a finder of fact so that they can make that determination.
Could I ask you about your contract claim?
Certainly.
It seems to be based on the notion that the contract requires that notices be sent by mail. Does that preclude the parties from what if your client wants the money to be wired ASAP? How does that jive? What does the term notice encompass? Does that include wiring instructions from your client asking that something be done ASAP?
Well, if one looks at the contract, and again, I say that because if one looks at the case law, as no one disputes, the case law requires an escrow agent to strictly comply with the terms of its contract. Strictly comply.
But if they were to have sent out a notice by mail at the same time they're sending out the wiring instructions, and it says, I want you to wire this by 5 o'clock this afternoon to this email address, what possible utility is served by, why would that matter if they send a notice in the mail to each of the parties?
Well, they would have gotten to the Fulghams. I'm assuming that the mail would have gotten to the Fulghams, and the Fulghams would have said, hey, wait a minute, what are you talking about, JG Art and Designs Corporation?
But my question though is, if your client says, this needs to close by tomorrow or by this afternoon at 5 o'clock, that doesn't seem to leave any time for mailing.
Well, I understand the court's question. My point being in the argument is that if Arizona Escrow wants to change the terms of its contract, it seems to me that it needs to go to the parties and say, look, to both of them, and find out whether or not that's agreeable to them. I don't know. In fact, that didn't happen in this case. I think if it had been done, because again, the obligation is contractual on Arizona Escrow, but also legal to strictly comply with the contract. If that's the case, then it seems to me incumbent upon them to say, wait a minute, you've got to take an extra step to go to the parties, and if they want to change it to use email or some other communication, to have to do it that way. But I think if the contract had been strictly followed, the outcome in this case would have been very different. Your Honor, unless the court has other questions, and I don't want to cut it off if it does, I've got 3 minutes remaining.
No. Thank you, counsel. Counsel.
Thank you, Your Honor. Roger Cohen on behalf of Applee Arizona Escrow. May it please the court. There are really two overriding factors in this case, and I'm not sure they came through in the argument we just heard. Number one, Mr. Mago had knowledge that he didn't share with Arizona Escrow. He knew there was a problem with his account. He didn't tell Arizona Escrow. Conversely, Arizona Escrow had no actual knowledge of the difference in the email addresses. That's only something that people picked up after the fact.
Well, counsel, does that make a difference, though, if Mr. Mago is not the one who introduced the fake email to your client? Because the only record that we have, I think, because as Judge Catani mentioned, we don't have an email that shows that Mr. Mago is the one that introduced the email address itself to your client. If I'm mistaken?
Yes, I mean, with due respect, yes, you're mistaken. The first email that comes that shows that the bad address is the one sent at 6:02 p.m. on November 21st, which was from Mago to Fulgurn. I have written to Helen to release the money ASAP. Please send her the wiring instructions. That
Right.
is the first email from, sorry.
Right, but my question is, was it Mr. Mago who, we don't have anything, and again, maybe I'm missing something, but where Mr. Mago's the one that throws in that email. The only time that your client sees that email address is when that imposter emails both Mago and your client on the morning of November 22nd at 4:40 a.m., where that's the first time that we see, I think, an email that has all three emails on it, meaning the imposter's email combined with Mago's email combined with your client's email. And that's because that imposter emailed both Mago and AZ Escrow at 4:40 a.m. on November 22nd saying, hey, here are the details of the banking where I want the wiring. And it kind of took off from there. As opposed to Mr. Mago being the one who CCs the imposter and AZ Escrow and says, hey, here, AZ Escrow, you take it from here with this fake email address. Do you see what I'm saying?
I see what you're saying, Your Honor, but we disagree.
Well,
So
show me where Mr. Mago then
this
is the
would
one.
be Exhibit 6 to the Statement of Facts. On November 21, 2016, at 6:02 p.m., Mago wrote to DJ Fulgurn at AOL.com, copying Helen Westbrook at Arizona Escrow on that email.
Okay.
What was Mago's explanation for why he had the incorrect address? Had he received an email from that address previously, or do you know?
Well, Your Honor, here's the problem. We know that he must have, but he, according to his testimony, changed his email address when this was all done and erased all his old emails. He didn't save any emails. So we have no ability to document what emails he got because he erased them. What we do know is that Arizona Escrow never received an email directly from Fulgurn. It was introduced into Arizona Escrow's file by the email from Mago. So there's nothing Arizona Escrow could have done or could do or could have known because it came from Mago.
Well, but this email on November 22nd comes from Fulgurn, from the incorrect address that goes to both the escrow company and Mago, right?
That is correct, Your Honor.
Right, and I'm not seeing, counsel, when you say that November 21st at 6:02 p.m., which is clearly from Mago to the imposter, but I don't see that being CC'd to your client. I see the next entry being, again, the email from the imposter to both Mago and your client.
Well, he sent it. Your Honor, we know he sent it to Arizona Escrow. Let me pull up the.
Well, it was sent to Arizona Escrow because it was attached to, it was a response. I mean, Fulgurn took that and then attached the original. You see what I'm saying? There's a difference between.
No.
Your client has possession of that email.
This is part of.
I'm on Exhibit 6.
And we're looking at the email at 6:02 p.m.
Right, and I see the name at the top is Helen Westbrook, and I see that there's an email there from Fulgurn, the imposter, to both Mago and your client, which is why your client has it, but it's from the imposter, and the imposter is the one who has attached the original message that was from Mago to the imposter. But I'm just saying it wasn't like Mago is the one who forwarded that to your client and said, oh, here's the email address you should be contacting now.
Well, no, I think that's a distinction without a difference. At 6:02, Mago sends an email to the wrong email address saying, money is in escrow. I've written to Helen to release the money ASAP. Please send her the wiring instructions. So Mago is asking Fulgurn to send the wiring instructions. Okay, so then the very next thing that happens at 4:40 in the morning is the user of the Fulgurn address sent an email to Mago with a copy to Arizona Escrow, subject money is in escrow, bank detail, and I don't think we have the attachment on this copy, but sending the wire instruction. Helen attached the bank detail for wire. So the Fulgurn user is doing exactly what Mago said to do, and that's the first email to Arizona Escrow from Fulgurn. But Mago the day before had already been communicating with Fulgurn. We know that because, and that's outside the scope of anything that Arizona Escrow had any involvement with. Naresh Mago to Fulgurn at 6:02 p.m. on November 21st. So how can Mago claim that Arizona Escrow had prior knowledge or prior notice? The timing just doesn't work, Your Honor.
But Counsel, I've been listening to this discussion, and you raise valid points. We all do, but it seems to me that we're not the trial judge in this court. We're not the right court to parse through all the facts and figure this out. That this is more properly a matter for a jury to figure out. So, can you address that?
Yeah, let me respond to that. I never got to the second branch of the argument. The point is that none of this matters. Where it came from first, all that, that's not the important thing. The important thing is that and it is not contradicted. There is no dispute that Arizona Escrow did exactly what Mr. Mago asked them to do. And after it was done, Mr. Mago ratified, approved, and thanked Helen for doing it. So,
Counsel, can I ask, what if the address for the Fulghams had been at djfulgham@pyramidscheme.com? I mean, would that have, and that was in the email, would that have triggered some obligation on the part of the escrow company to say this? Are you sure this is the right email address?
I'm sorry, I'm struggling. That's a great question. If that had happened, everybody would have known. But that's not what happened.
But isn't that the question? Is whether it's obvious if something like that is in there? But if they previously had a different email on file for the Fulghams, that's the correct email address, and it seems like a really good argument to the jury that how could we possibly know? And this was introduced by Mr. Mago. But if you're saying a jury would be entitled to look at it if it said at pyramidscheme.com, why is he not entitled to make that argument to the jury that this is just like as if it said pyramidscheme.com? And I'm not sure a jury would buy that, but it seems like it at least raises an issue of fact for a jury to consider.
The answer, Your Honor, is that Berkman talked about the disclosure of facts that are known to the escrow agent, from which the escrow agent knew or should have known that there was a fraud.
But did the escrow agent know the Fulgham's correct address prior to receiving this email from Mr. Mago?
Sure. Yes, Your Honor. But that's not the question. The question is, what did the escrow agent know? And also, there's a little sleight of hand there. The point of disclosure is for the escrow agent to tell the party something that the party doesn't already know. The escrow agent doesn't have to tell the party things that are in the party's knowledge and possession. The idea is that where the escrow agent has superior knowledge, remember, we're back-to-back escrow. And so what the escrow agent knew that, and the buyer knew that, the seller didn't know that. And so under those circumstances, the court says, look, escrow agent, you have these facts in your possession, and a reasonable escrow agent would have known from these facts that there's something going on, and therefore you have the obligation not to disclose the fraud itself, but to disclose the facts. Okay, in our case, Arizona escrow, it doesn't parse out. Arizona escrow, yeah, after the fact you can say, oh, it was in your file, but the escrow agent had no conscious knowledge. So now we're extending Perkins to require an escrow agent not only to know what it knows, but to know what it could have figured out had it done something else, and that's not the standard. But again, we're still far away from the real issue here, which is that when we got to the end of the string on the 22nd, Helen Westbrook properly asked the question to Mago, is this the right address? And the answer comes back from Fulger, yeah, JG Art Design Corp, that's our company. So at that point, Mago is expressly aware that the error, and that's where the escrow agent is doing exactly what it should have done, is disclosing that fact. And that's the point where if Mago thought there was something going on, or if Mago didn't want the wire to be sent to this company that had nothing to do with the transaction, then Mago should have said something. But not only did Mago not say anything, a little later, on the 22nd, Helen Westbrook sends to both Folger and Mago attached, please find the confirmation wire, which shows exactly where it went. And Mago responds, thank you, Helen. And that's the end of the case, Your Honor, because you can't create this duty after the fact to do something to save Mago from himself. Mago asked the escrow agent to wire money. And in answer to that question, by the way, that goes all the way back to the 15th of November, a week before, where Mago wrote to Helen Westbrook saying, I want to transfer money before closing. And now you're a week later, and we've gone through all this back and forth, and Helen properly noticed, you know, are you sure this is the right address? Mago doesn't pick up doesn't make anything of that other than say, yes, please do it. And you can't protect someone from themselves. If the escrow agent in Perkins had said, hey, everybody, there's a back-to-back escrow here, and the parties had closed anyway, how would that have been the escrow agent's fault? The issue, the only issue is knowledge. And the escrow agent in this case made sure that the relevant knowledge was imparted to the party, to Mr. Mago. And Mr. Mago, in the face of that expressed knowledge, said, thank you, Helen. And, you know, he doesn't like the consequence of that, but it's not because of anything the escrow agent did. Because the escrow agent followed the instructions. I'm sorry, Your Honor.
Cancel. So the job of the escrow company is to do exactly what the party is saying, not to see that the transaction is properly conducted according to the escrow agreement.
Well, Your Honor, the escrow agreement is, in this case, the contract and the escrow agreement were one and the same. And the parties have the right to change that. And in this case, again, Mr. Mago is the one who changed it. And apparently he changed it with the consent of the other party, because that goes back to the 15th of November. And
but he wasn't trying to defraud himself. He believed incorrectly, it turns out. He was dealing with the correct party when he was not. And I guess, as I understand it, and correct me if I misunderstand it, but the question is, to what extent is the escrow company responsible for making sure that the proper party is identified?
Well, Your Honor, that again requires knowledge from escrow agent. But here's the thing to keep in mind: it's not that we're saying that Mago is trying to defraud himself. For whatever reason, and it had to do with Mago's finances. that he needed time to close this escrow. Which, by the way, he was never able to close, and in fact, it turned out that Subway declined to approve him, but he never could get approved. Perhaps for reasons having nothing to do with Arizona escrow. They just thought he was a bad operator. He decides that he's going to send money to the seller to get some extra time to perform. And by the way, one of the interesting things about this case is that we never got testimony from Fulgham, the real Fulghams, because we couldn't serve them. They were avoiding service, which I find extraordinary. If they're the ones that were in the middle of this and were arguably victimized, why were they so shy about showing up? Why couldn't we get them to testify? Why couldn't we get something served on them? I can't answer that question, but that's the truth. That's why we never got the ability.
Counsel, was there any correspondence or any emails from the correct Fulghams around the time of closing? Is there anything from them saying, where's the money, or is this going through?
Yeah, on November 20th, Your Honor, the real Fulgham wrote to Mago, who is financing the balance of $199,000 plus your share of escrow fees and transfer fees. And Mago responds, you don't need to worry, I will close the deal. Like I said, I have the money. That's 2 days before, and the context that he's talking about, the balance, is that that must have been part of a longer string of communications about money being released early. But again, we don't have the rest of that conversation because Mago didn't save his emails and because Fulgham is avoiding service. But the escrow agent can only know what it knows. And if there are communications going on between Fulgham and Mago, and neither of them is saving a record of it, and neither of them is willing to provide it under a subpoena, there's not a whole lot we can do about it. So I'm not sure how else to answer that, but the short answer is yes, the real Fulgham is absolutely communicating, and it appears pretty clearly that they were asking for this money. And what we think happened, Your Honor, is that someone was lurking in Mago's email account, and someone saw that, hey, there's going to be money coming to Fulgham. And it was at that point, or maybe they were lurking in Fulgham's account, now that I think about it. But in whichever way it was, somehow the imposter got the idea, hey, I can intercept this transaction by pretending to be the transferee. And by the way, there are some email addresses, the emails from Mago also were using the difference between M and RN. There's a fake Mago address floating around here someplace too. That is not part of this series of communication. But the escrow agent somehow should have figured it out. Very right. Yes.
Counsel, your time is up. Would you like to briefly summarize?
I'm sorry, Your Honor, the screen was switching. I'm not sure what the question was.
Sure. Your time is up. Would you like to briefly summarize?
Yes, Your Honor, thank you. I think I've gone through the issue about the email and the approval of the transaction. As to Caldwell's expert opinion, it's not in the full opinion is not in the record. There was only some brief excerpts that we inserted. But what the issue that I was getting at in the deposition is who gets the notice? Do you send it? Is it the sender or the recipient? And so this is at. I'm sorry, I can't get the specific, but it's in I think it's at page 15 of the deposition. Who the escrow agent they're worrying with?
I'm sorry, Counsel. Your your time is up.
Okay. All right.
Thank you.
Any other questions, Your Honor?
No, thank you.
Thank you, Your Honor.
Counsel?
Thank you, Your Honor. I have just a few minutes of rebuttal. I do want to address a couple of things that were said that were not really part of the, in fact, not a part at all of the trial court record with regard to Mr. Mago. The idea that he was a bad operator or that he couldn't close. I mean, Mr. Mago owns several subway locations. So it's not a matter of him being a poor subway operator. That wasn't part of the argument in the trial court either.
Counsel, is there any indication of, are there any emails from the Fulghams after saying, what's going on, where's our money?
Your Honor, there was an exchange, which I think is part of the record in the exchange between Mr. Graham, who is the president of Arizona Escrow, and Subway. The Subway Arizona franchisor, overall franchisor, got involved in the case, and after the monies were lost, and there was an exchange with Arizona Escrow. And at that point, Arizona Escrow said, or excuse me, the Subway said, we're not going to close this deal because the Fulghams were entitled to their monies and the Magos could not pay that, given the loss of the $80,000, $79,000. So if you're asking, I'm trying to remember your question again, Your Honor.
I was just wondering, it seems like if you're the Fulghams and
Yes.
you're expecting this sale to close, you presumably want this to close. And it seems odd that there's nothing in the record from the Fulghams that say, what's happening, where's our money?
Well, there was, because they wanted to close the deal, but our client did not have the purchase price money because it lost the $79,000, Sean. So, but there were contacts between the Fulghams, particularly between the Subway franchisor who stepped in for the Fulghams and Arizona Escrow, where that was in exchange with Don Graham, who again is the president of Arizona Escrow. We provided that as part of
What's your response to Mr. Cohen's argument that all of the cases that address this involve some knowledge on the part of the escrow agent?
I don't think that's an accurate representation, Your Honor. For example, in Maxfield versus Martin, the escrow officer who gave the money to the imposter didn't have knowledge that was that the person who came in and received the money was an imposter. They had an obligation to verify that information. So I don't think that's a correct statement. In fact, there's a case, if I can find it, Your Honor, I apologize, where a court found responsibility when an escrow agent failed to notice that there were not two different fax confirmations on a document that should have been apparent. And so it's not a matter that you can just say, look, I'm going to, you can't say, look, this is not a theoretical question. You say, I'm going to turn a blind eye to that. They have an obligation to look and observe. And I think that's a better statement of what the law is when one looks at Maxfield and Burkons and some other cases that were cited in Arizona. They have an obligation to not just to ignore things that they have. In summation, briefly, what we're asking for, Your Honor, is a return to the trial court so that we can present the facts to a jury and have the jury make a conclusion. If the Magos had the cases about Arizona Escrow's duties, things with regard to Mr. Mago could be considered and seen as comparative negligence. That's still a jury issue, and that's what we're asking for. Thank you, Your Honor.
We thank you, counsel. We appreciate your argument, and we'll take this matter under advisement and issue a decision in due course. We stand adjourned. Thank you.
Thank you, Your Honor. Thank you, Roger.